name is Marete. I request that you place us on record together with Mr. T.K. Ruto for the accused.
Mr. Kimani?
Yes, the record remains the same, Your Honor. I appear for the victim. Thank you.
Peter Kimathi, Kinyua, and Kibet, Torut. You've been charged by obtaining goods by false pretense, contrary to Section 313 of the Penal Code, Chapter 63, Laws of Kenya. On the diverse dates between 1st January 2024 and 24th January 2024 at Nairobi City within Nairobi County, in the Republic of Kenya, jointly with another not before court, with intent to defraud, obtained from Peter Njuki goods, namely 2383 bags of 60 kgs Kenya Arabian coffee valued at 115 million by false pretending that it was a genuine coffee supply contract between Savikov Limited and Gili Investment Limited. The fact you knew to be false. Peter Kimathi, Kinyua, true or false?
False.
Kibet, Torut, true or false?
False.
Not true, Your Honor.
First of all, in the event that there are any documents, statements to be relied on, we request that the same be supplied to us immediately. But more importantly, and most urgently, and with great humility, we do request, Your Honor, that you admit these persons to lenient bail terms. We suggest with humility that you admit them to cash bail. There are numerous reasons for this. The first of which is that these persons are certainly not a flight risk of any sort. And they are looking forward to debunking these spurious charges that have been brought against them, which charges, Your Honor, as you have heard from the charge sheet, stem from a commercial contract for the supply of coffee between companies which have done business together for close to a decade. Save that in this instance, the person who now purports to bring this complaint did not meet the end of the contract, leading to difficulties in the settlement of the funds due. But even having said that, we are surprised to hear that we are told that this was not a genuine contract, and yet that counterpart to date, Your Honor, has received over 67 million shillings in payments. The equivalent over 67 million shillings towards the consideration. That was $515,000 out of a possible $882,000. And $82,000. In fact, when the idea of criminalizing this commercial transaction was first mooted and began to rear its ugly head, and the accused persons were summoned, by the police and cautioned, they were admitted to a cash bill at the time. If my memory serves me correctly, it was about 100,000 shillings, which was paid to the capital police station at the time. Since that time, since the issuance of that cash bill, on the 31st of October 2024, the purchaser in the contract,
31st October.
2024, the purchaser paid 40 million shillings. On the 5th of February 2025, the purchaser paid a further 10 million shillings. And on 2 occasions thereafter, paid $24,000 and $100,000 respectively. That is what adds up to the amount I mentioned to you has been received. Even more curiously, Your Honor, is that the complainant, who has now led to a charge sheet alleging that the accused persons were purporting or pretending to act on a genuine coffee supply contract, has filed a civil suit in the High Court. That is High Court Commercial Case number E289 of 2026. 89 of 2026, where a company known as Geely Investments Limited has sued a company known as Savikov Limited on the basis of this same contract, demanding payment. That suit, Your Honor, is still pending in the High Court. And for good order and in the interest of full disclosure, the defendant there has filed a preliminary objection asserting that when all is said and done, that coffee contract included an arbitration clause referring any dispute arising in that contract or from that contract for settlement by arbitration in London under the rules of the British Coffee Association. I am able to supply these copies of the documents I have made reference to, and the court can peruse them. And I just end by saying that ultimately this is a case where this court is being used as though it was a debt collector, a commercial dispute has been weaponized, and the very charges have achieved the ulterior motive that was intended all along. That is to bring maximum public humiliation to this gentleman. Only because of what has been a difficult business transaction. Your Honor, as you consider the matter, I urge you to take note that every time there was someone to the police, they cooperated, they attended the DCI, only to be ambushed. In the case of the first accused, by being arrested at his residence in the dead of night. And in the case of the second accused, in the precincts of the court, as he was coming to attend the arraignment of the first accused. These are not people who have any intention of running away from this matter. They have roots here. They are well-established businessmen. They may be facing a temporary business difficulty, but it does not warrant the stripping of their rights by way of this malicious prosecution. And I urge you, I plead with you, to exercise your discretion ever so leniently. If I dare suggest, Your Honor, consider cash bail to enable them process the same and return to their families without the challenges of other terms of bond, and in keeping with the previous amounts that had been set at the police station, the Capitol Hill police station. I ask so with great humility for both parties.
Yes. The court's jurisprudence have actually been long established we have the commercial, the civil division, the environmental, employment, etc., etc. And Your Honor, maybe because of non-disclosure by the complainant or otherwise, not knowing, this court has been invited to be a debt collector. It's a total abuse of the court process. It is a total disintegration of the jurisprudence developed from time to time. It's an abuse of the Constitution. And it's an abuse of the fundamental rights enshrined under the Constitution as against arrested persons. By making what is purely civil to be criminal. Which ought not to. And having judicial notice that substantial payments have been made. The question is, what criminal intent is there? What criminal intent did the complainant have vis-a-vis the accused? It only relates to one thing. It is mala fide, actuated by malice, and not to achieve the interest of justice for both the complainant and the accused. We humbly urge this honorable court leniently to consider submissions made, documents tendered before you, and exercise your discretion and admit both the accused persons to lenient terms of cash bail, and to refuse the courts being abused to be debt collectors. I humbly pray so. Thank you.
Issues have been raised by the defense counsels.
Your Honor, I object to counsel's submissions. I do believe that at this point we are dealing with a taking of plea and dealing with a constitutional issue of bail. Counsel watching brief has no audience and no locus at this stage other than to add salt to injury and possibly inflame passions in this matter. His client will have his time. Today we are dealing with a simple issue of the liberty of the arrested persons. It has nothing at this point to do with the complainant. The complainant has had their day. Their charge sheet is now before the court. Between the DPP and counsel for the complainant, they will be able to put their case forward. As you can see, they are not even ready to give us the documents which they will be relying on to prosecute our clients. So at this point, I do implore the court to focus solely on the issue of the rights of the arrested persons. I believe this is a matter that has been settled, Your Honor, and I believe it is in a Republic versus Aori and another criminal appeal number 023 of 2021, where the court was called upon to determine whether E023 of 2021, Aori and another. Aori. A O R I and another. Where basically the ratio was that the watching brief is limited to the rights of the complainant, and those have not yet crystallized. We do not even know whether there is a victim in this matter. Only a trial will tell us that. A victim will arise when there is a decision as to whether there is guilt or there is no case to answer. Right now, there are only allegations, and they have come as far as they can by the charge being laid before these people. I implore you, Your Honor, let us focus on the rights of the arrested persons, on the question of bail. The rest of the issues will be dealt with later. Liberty, and that's all. The decision that has been put before you, it only confirmed that there is a constitutional right by the DPP to charge and by the DCI to investigate. That's all. It didn't delve into any other issues. And I suppose His Lordship was right. So ultimately, Your Honor, do not impede the liberty of the accused people. Let their conduct prior to this date be looked upon favorably. I urge you again, finality, to be lenient in the terms that you shall set.
No, E488 of 2026, the arguments by Ms. Semo, prosecution counsel, and the arguments by counsel Mr. Kimani, watching brief for the complainant. First, the accused persons have been arraigned in court today. Therefore, the question of them facing possible prosecution does not arise because in any case, the High Court dismissed the petition filed by the accused persons and Savikov Limited, which Mr. Kimani has availed to the court. Second, the prosecution does not oppose the accused persons being granted bail/bond, and the prosecution has not filed an affidavit opposing bail/bond. That being the case, the court cannot assess the risk of them absconding court without reasonable grounds being provided as required under the bail and bond policy guidelines. So therefore, the argument by Mr. Kimani urging the court to assess their likelihood to abscond court is not supported. I also do take note that Mr. Kimani urged the court to consider the amount lost by his client is a sum of 115 million. So the High Court has held in a myriad of decisions that the amount stated in the charge sheet is not the determining factor on the amount of bail/bond that is to be granted. Being that the prosecution does not object to the accused persons being granted lenient bail/bond terms, then the accused are entitled to such reasonable bail/bond terms. I do take note that Mr. Kimani confirms that the two accused persons had been granted a police cash bail of Kenya shillings 200,000 each. If that is the case, and they're in court today, then they also do understand their need to comply with the court's conditions on their release. And whereas I have considered the arguments, I've also considered the arguments by Mr. Kimani, counsel watching brief, which I wish to point out the Supreme Court decision in Waso versus the Republic that set out the parameters to be considered in determining the participation of counsel watching brief during proceedings. I also do wish to point out that in 2024, Lady Justice Mugure Thande declared the definition of a victim under Section 2 of the Victim Protections Act unconstitutional for failing to consider the legal/juristic persons as victims. Nonetheless, and thirdly, I have found that having found that the accused persons in this case are entitled to reasonable bail/bond, that's the accused in 487 and 488, they are granted bail/bond in the following terms. Each of the accused to be released on a bond of Kenya shillings 700,000 with one surety of a similar amount, or a cash bail of 350,000 each with one contact person each. The two accused persons must attend court at all times, and being that this matter is related to criminal case E488 of 2026, the submissions by counsel and this ruling shall apply in criminal case 488 of 2026. The prosecution to supply the defense with witness statements and documents and an inventory to be filed.
We're very grateful.